Students, welcome to my YouTube channel Your Short Questions with Narayan. ये तो आएगा ही. In this video, we are going to discuss about the law of contract, essentials, void and voidable contract, consideration, termination of a contract, offer, counter offer, and acceptance. It contains the most probable questions and answers for your semester exams. It is also important for CLAT and AILET aspirants. Let's move to the contents. Define contract. What are its essentials? Section 2H of the Indian Contract Act 1972. A contract is an agreement enforceable by law. Is this section you must remember. To constitute a valid contract, certain essential elements are offer and acceptance, consideration, lawful object, capacity to contract, and the free consent. The case law in this regard is Carlyle versus Carbolic Smoke Ball Company case. Second case is Mohri BB versus Dharmadas Ghosh case. What are the two key components that form the basis of contract? They are agreement. An agreement arises when one party makes a proposal or offer and the other party accepts it. These are the key points you must remember. One party makes a proposal or offer and the other party accepts it, then it becomes an agreement. As per section 2E, an agreement is defined as every promise and every set of promises forming the consideration for each other is an agreement as defined in section 2E of the Contract Act. Enforceability by law. The second key component is an agreement becomes a contract only if it is enforceable by law. This means that the agreement must meet certain legal criteria to be binding on the parties involved in the agreement. Discuss the essential elements of a valid contract with relevant case law. This could be a question of 10 marks. The essential elements of a valid contract are offer and acceptance. There must be a lawful offer by one party and a lawful acceptance of that offer by another party. Case law is Carlyle versus Carbolic Smoke Ball case of 1893. In this case, it was held that an advertisement containing an offer to the public, when accepted by performance, can form a binding contract. The company's offer was accepted when the plaintiff used the smoke ball and followed the conditions, forming a valid contract. Second is intention to create legal relation. Both parties must intend to create legal relation and be legally bound by the contract. Agreements of a social or domestic nature are generally presumed not to have the intention to create legal relations. The case law is Balfour versus Balfour of 1919. In this case, it was held that agreements between spouses are presumed not to be legally binding as they lack the intention to create legal relations unless expressly stated otherwise. This was held by Lord Atkin. Lawful consideration is another essential element. As for section 2D, consideration is an essential part of a contract. Consideration refers to something of value given by both parties to a contract. It can be an act, forbearance, or a promise to do or not to do something. The case law is Chinnaya versus Ramaya. It was held that consideration can move from a third party and does not necessarily have to move from the promisee. The next fourth essential is capacity of parties. The parties to the contract must be competent to enter into a contract. Section 11 of the Act specifies that a person must be of the age of majority, of sound mind, and not disqualified by any law to which they are subject. Case law is Mohri BB versus Dharmadas Ghosh. It was held that a contract entered into by a minor is void ab initio. This is an important question for competitive exams. Ab initio is from beginning, as a minor lacks the legal capacity to contract. Free consent. Consent to the contract must be free. As per section 14, consent is considered free when it is not caused by coercion, undue influence, fraud, misrepresentation or mistake. These are the 5 keywords you must remember while making a point on free consent. The case law is Ranganaikama versus Alvar Sethi. The court held that consent obtained by coercion is not free consent, and any contract based on such consent is voidable at the option of the aggrieved party. That means at the option of the victim. Lawful object and lawful consideration. The object and consideration of the contract must be lawful. Section 23 specifies that an agreement with an unlawful object or consideration is void. Here the case law is Gherulal Parekh versus Mahadevdas Maya. It was held that an agreement with an unlawful object such as one to defraud the revenue is void and unenforceable. Next essential element is certainty of terms. The terms of the contract must be certain and not vague. Section 29 of the Act states that agreements, the meaning of which is not certain or capable of being made certain, are void. Case law, Scammell versus Austin. The court held that a contract that is too vague or uncertain in its terms cannot be enforced. Possibility of performance. The contract must be capable of being performed. Section 56 states that an agreement to do an act impossible in itself is void. Case law is Satyavrata Ghosh versus Mugni Ram Bangar and Company. The Supreme Court held that if an unforeseen event renders the performance of the contract impossible, the contract becomes void under the doctrine of frustration. For example, if there is a person from Pakistan and one person from India, both entered into a contract to supply some products, but suddenly a war breaks out between India and Pakistan, then this contract becomes void under the doctrine of frustration. Not expressly declared void. The agreement must not be one that the law expressly declares to be void. Certain agreements, such as those in restraint of trade, section 27, or restraint of marriage, section 26, are void. Question number 4. An agreement to be enforceable as a contract under the Indian Contract Act, there must be an intention to create legal obligations. Simply making a promise or agreeing to something does not automatically result in a legally binding contract. Explain. Question. This is a 5-mark question. Answer is Section 2E of the Indian Contract Act defines an agreement as every promise and every set of promises forming the consideration for each other is an agreement. The case law is Balfour versus Balfour. The case summary. In this case, Mr. and Mrs. Balfour were a married couple. Mr. Balfour, a civil servant, promised to pay his wife a monthly allowance while he was working abroad. Later, the relationship deteriorated and Mrs. Balfour sought to enforce the promise made by her husband. The issue before the court was whether the question arose whether this agreement was an enforceable agreement under the law. The court held that there was no intention to create legal relations between the parties and hence the agreement was not legally enforceable. The court clarified that not all agreements are contracts, only those agreements that are intended to have legal consequences qualify as contract. The court further held that in this case, domestic arrangements between wife and husband are not illegally intended to perform. Differentiate between void and voidable contract. It is a 5-mark question. The basis and void and voidable contract. A contract that is not enforceable by law from the beginning is a void contract. And a contract that is valid until one of the parties chooses to void it is a voidable contract. Means that it is at the option of the aggrieved party. If the aggrieved party wants to declare it is void, it can be declared. So it is voidable. Relevant section 2G of the Indian Contract Act defines void contract. Here it is section 19 of the Act deals with voidable contract. Enforceability. Void contract cannot be enforced by either party, and voidable contract is enforceable by law at the option of the aggrieved party. Legal effect. No legal effect from the beginning because this is void from the starting point on void contract. The voidable contract has legal effect until the aggrieved party voids it. Consent. Consent is usually not free or legally valid, making it void in the case of void contract. In voidable, consent is usually free, but there might be factors like coercion, undue influence, or fraud affecting it. Example, agreement to do an illegal act, that is, a contract to commit a crime, is void. A contract signed under duress or fraud, coercion to sign a property deed is as an example of voidable contract. Example of case law, Gerulal Parekh versus Mahadev Das Maya. The court held that an agreement entered into for a wagering transaction is void and unenforceable. In voidable contract, Ranganayakama versus Alvar Sethi, the court held that a contract executed under coercion where the consent of the plaintiff was not free was declared voidable at her option. What is meant by consideration in the context of contract law and what are its legal requirements? The consideration is something of value that is exchanged between the parties to a contract. It must be lawful, real, and not something that is forbidden by law. Consideration is necessary for a contract to be valid as stated in section 2D of the Act. An offer can't be accepted after it has been terminated. Explain when an offer ceases to be capable of acceptance. Answer. A contract law, an offer ceases to be capable of acceptance under the following several circumstances. One is revocation. An offer can be revoked by the offerer at any time before it has been accepted. For revocation to be effective, it must be communicated to the offeree. The offer is no longer capable of acceptance once it has been revoked. Second is rejection. If the offeree rejects the offer, it is terminated. A counter offer, which is a response to the original offer with different terms, also constitutes a rejection of the original offer. Therefore, the original offer is no longer capable of acceptance. Third is lapse of time. If an offer specifies a time frame for acceptance, it ceases to be capable of acceptance once that time period expires. If no time frame is specified, the offer will lapse after a reasonable period, which depends on the nature of the offer and the circumstances. Death or insanity. If either the offerer or the offeree dies or becomes legally insane before the offer is accepted, the offer ceases to be capable of acceptance. The offer is considered terminated in such cases because the contractual capacity of the parties is affected. Fifth is failure of a condition precedent. If an offer is contingent upon the occurrence of a certain condition and that condition is not fulfilled, the offer becomes incapable of acceptance. Illegality. If the subject matter of the offer becomes illegal before it is accepted, the offer is terminated. For example, if a law is enacted that makes the contract's purpose illegal, the offer cannot be accepted. An offer ceases to be capable of acceptance when it has been revoked, rejected, lapsed, or when the offerer or offeree loses capacity or when the offer becomes illegal. Question number 8. Explain termination of contract as per section 6. Section 6 of the Indian Contract Act 1872 deals with contracts that are considered void from the very beginning due to various reasons. The section outlines specific circumstances under which a contract is deemed void ab initio and thus cannot be enforced. Here is a breakdown of the types of contracts that are terminated as per section C. Agreements that are not contracts. Agreements that are determined by law to be void. This includes agreements that are expressly declared void by law, such as agreements to commit a crime or agreements that go against public policy. Agreement by contracting parties. Agreement to perform an impossible act. Agreements that involve the performance of an act that is impossible are void. For instance, if an agreement is made to perform an act that is physically or legally impossible, such a promise to bring a dead person back to life, it is void. Agreements with uncertain terms. If the terms of an agreement are so vague or uncertain that the performance cannot be determined, it is void. For example, If a contract does not specify the price of goods or services, it may be considered void due to uncertainty. Agreements without free consent. Contracts made under coercion, undue influence, misrepresentation or fraud are voidable, but if they are such that they cannot be rectified or made valid, they can be deemed void. Agreements for consideration of illegal subjects. If the consideration or object of the agreement is illegal, the contract is void. For example, a contract to sell illegal drugs is void. Agreements in restraint of marriage. Contracts that restrain a person from marrying are considered void. However, reasonable restrictions on marriage agreements can be valid if they are made in the interest of the person's future spouse or family. Agreements in restrained trade. Contracts that restrain a person from carrying on a lawful trade or profession are void. However, there are exceptions for reasonable restraints in certain circumstances. In summary, Section C of the Indian Contract Act specifies that contracts are void if they are formed under circumstances that render their performance impossible, uncertain or illegal, or if they involve terms that contravene public policy. Explain consideration as per Contract Act. Consideration is defined as something of value that is exchanged between the parties involved in a contract. It is a fundamental element for the formation of a valid contract. Section 2D of the Indian Contract Act defines consideration as when at the desire of the promisor, the promisee or any other person has done or abstained from doing or does not abstain from doing or promises to do or to abstain from doing something, such act or abstinence or promise is called a consideration for the promise. In simpler terms, consideration refers to the benefit or detriment that each party receives or incurs in exchange for the promise. It can be an act performing a specific action such as delivering goods or services, an abstinence refraining from doing something that one has a right to do, a promise agreeing to perform or refrain from performing an action in the future. Key aspects of consideration. One is legality. The consideration must be lawful. Any consideration that is illegal or go against public policy will not be valid. So one is legality. Second is adequacy. While the consideration must be real and have some value, it does not need to be equivalent or adequate in terms of market value. Courts generally do not evaluate the adequacy of consideration as long as it is not illegal or immoral. Then next is past consideration. Consideration must be present or future. Past consideration, which refers to something that was done before the promise was made, is generally not valid under Indian law. Mutuality. Both parties must provide consideration for their respective promises. In a bilateral contract, each party's promise must be supported by a consideration. Consideration is essential for the enforceability of a contract. Without it, the contract is generally considered void as there is no legal binding agreement between the parties. Explain offer and acceptance of offer in an Indian Contract Act with a case law. This could be a question of 10 marks. Under the Indian Contract Act 1872, the concept of offer and acceptance are crucial for the formation of a valid contract. Offer. An offer is a proposal made by one party to another with the intention of creating a legal obligation upon acceptance. The offer must be clear, definite, and communicated to the other party. The essential elements of an offer include, these are the words you must remember. The offer must be clear, definite, and communicated to the other party. The essential elements are intention. The offer must be made with the intention to create a legal obligation upon acceptance. Definiteness. The terms of the offer must be clear and certain. An offer that is vague or ambiguous is not valid. Communication. The offer must be communicated to the offeree. An offer that is not communicated cannot be accepted. Acceptance. Acceptance is the assent or agreement to the terms of the offer made by the offeree. For acceptance to be valid, it must meet the following criteria. Absolute and unconditional. The acceptance must be unequivocal and must mirror the terms of the offer without any modification. Unequivocal and must mirror the terms. Communication. Acceptance must be communicated to the offerer, and acceptance that is not communicated is not binding. Mode of acceptance. Acceptance can be communicated through any medium specified in the offer, or in no medium is specified through a reasonable medium. Case law is Carbolic Smoke Ball Company case. The Carbolic Smoke Ball Company advertised that its product would prevent influenza and promised £100 to anyone who used the ball according to the instructions and still contracted the flu. Mrs. Carlyle used the ball and contracted influenza, and she claimed the £100 reward. Issue: whether the advertisement constituted a valid offer and if Mrs. Carlyle's actions constituted acceptance. Judgment: the court held that the advertisement was valid offer to the world at large and that Mrs. Carlyle's use of the smoke ball in accordance with the terms of the advertisement constituted acceptance of the offer. The company's promise was enforceable as it was a unilateral contract, and Mrs. Carlyle was entitled to the £100 reward. Discuss a case on counter offer. A counter offer is a response to an original offer that modifies the terms. It effectively rejects the original offer and proposes new terms. This new proposal becomes a fresh offer that the original offerer can accept or reject. Case law is Hyde versus Renz. It is of 1840. In this case, the defendant Renz offered to sell his farm to Hyde for £1,000. Hyde responded with a counter offer to buy the farm for £950. Renz rejected Hyde's counter offer and later attempted to accept the original offer of £1,000. Hyde refused the acceptance. Issue was whether Renz's attempt to accept the original offer after rejecting Hyde's counter offer was valid. The court held that Renz's original offer was terminated when Hyde made the counter offer. Hyde's counter offer of £950 constituted a rejection of the original offer of £1,000. As a result, Renz's subsequent attempt to accept the original offer was not valid because the original offer had been terminated by the counter offer. Significance is this case illustrates the principle that a counter offer nullifies the original offer. Once a counter offer is made, the original offer is no longer valid and the offerer cannot accept it unless the counter offer is withdrawn and the original offer is reoffered. Application in Indian law. In Indian contract law, the principle of counter offer is similar to that in English law. According to Section 2A and Section 2B of the Indian Contract Act, an offer can be terminated by a counter offer which acts as a rejection of the original offer. The counter offer constitutes a new offer that must be accepted by the original offerer to create a binding contract. Case in Indian context is R. Venkatachalam versus B. Ramachandra Rao. In this case, Venkatachalam made an offer to sell his property to Ramachandra Rao. Rao responded with a counter offer with different terms. Venkatachalam later attempted to accept the original offer after Rao's counter offer. Issue: whether Venkatachalam's acceptance of the offer was valid after Rao's counter offer. The court held that the original offer was voided by Rao's counter offer. Since Rao's counter offer was made with different terms, it rejected Venkatachalam's original offer. Therefore, Venkatachalam could not accept the original offer after the counter offer was made. Significance of is that it reinforces the principle established in Hyde versus Renz and clarifies that in Indian law, a counter offer invalidates the original offer which cannot be accepted unless reoffered. A counter offer serves as a rejection of the original offer and introduces new terms. It effectively creates a new offer that must be accepted for binding contract to be performed. Differentiate between agreement and contract.